That happening time and time again starts to wear on me. And earlier this week, get out of my car, I'm walking into my house, and the FedEx truck backs up. The driver rolls down the window and goes, "There's my lawyer. How's it going, dude? I can't tell you how much I appreciate everything you did for me." I have no idea who he is. I don't know whether I did a tremendous thing for him or it was just another really easy case. But he was grateful to me. And all of a sudden, the guy who let me down, I forgot who he is. I like to think about the FedEx dude.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
We have two special guests with us, John Rockecharlie and Russ Stone. Not only are they colleagues that we work day in and day out with them, but they're also friends of mine and friends of Sharif. 35 to 37 years experience for each. So we got over 70 years of experience with two great trial attorneys from Richmond. Please introduce yourselves.
It's about 35 years now, started in 1989, went to Virginia Tech, had an undergraduate degree in psychology, couldn't figure out what to do with an undergraduate degree in psychology, and it was either go for 3 years for a PhD or go to law school. I decided I had more options available if I got a law degree. So frankly, that's how I fell into law school. I couldn't think of anything else to do. One of my internships, my third year of law school, was with the Henrico County Commonwealth's Attorney's Office. And when I did that, that's kind of when I decided I wanted to do criminal law and I wanted to be a prosecutor. I actually got to do my first jury trial as a Henrico County third year law student and lost. But upon graduation, I ended up prosecuting in Harrisonburg, Virginia, the Harrisonburg-Rockingham Commonwealth's Attorney's Office. Did a lot of cases back then because that was back before pre-1995 when they put in the bifurcated jury trial system. Before that, we had juries all the time, and I have no doubt John will agree with that as well. You were doing juries 2, 3, 4 times a week. After that, I went to the Virginia Attorney General's office in 1994, spent about 5 years there, and then went in 2000 to the Richmond multi-jurisdiction grand jury, doing essentially mostly drug prosecutions. And then finally in 2004, I decided to go into private practice, and it was in a different firm, but I went where John was, which we spent 12 years with that firm, and now we have our own firm.
Now you have Rockecharlie and Stone.
That's right. Exactly.
Speaking of Rockecharlie, John, please introduce yourself.
My name is John Rockecharlie. I was born and raised in Charlotte, North Carolina. Ironically, my parents were born and raised in Richmond, but a paycheck took my dad and our family to Charlotte in the early 50s. But anyway, so I grew up down there, attended the University of South Carolina undergraduate, go Gamecocks. And I was in my last year as a journalism major and had to take a journalism law class. And the adjunct professor goes, you should think about taking the LSTATs and go to law school. And I went, well, you know what? Law school, work. Law school, work. I think I like school. And so I took the LSTATs, surprisingly did well. U of R let me in graciously. And I said, you know what? I'm going to postpone the real world for 3 more years. That's why I came to law school. So then I graduate from law school, and just the challenge of the bar. I didn't even know I wanted to be a lawyer, but I wanted to take the bar because I wanted to pass the bar to say I could do it, and did it. Passed the bar the very first time. During my law school experience, though, I met a Richmond girl. And so I didn't want to go back to Charlotte because I wanted to stay in Richmond with a Richmond girl who I'm still married to. And so I passed the bar and I needed to figure out what I wanted to do. And a lawyer that I knew was a guy by the name of Charlie Cosby. And Charlie, I had done some work for Charlie, and Charlie was primarily a criminal defense attorney. And he said, you'd be a good prosecutor. Let me make a phone call for you. And it just so happened there was an opening in the Richmond Commonwealth Attorney's Office, and he got me in. He got me an interview, and then I got the job. Late 1987.
We often say, John, what makes great prosecutors or great attorneys is being a great human. And that allows you to connect to other humans and the trier of fact. And I see it in both of you, right? So clearly one of you, psychology, either took you to a psychologist or an attorney. Now, 35 years later, did you make the right decision?
Yes. I absolutely did. And you still use a whole lot of psychology in what we do now.
There's probably a considerable amount of overlap.
Absolutely.
Right? I mean,
I often look at it this way. A lot of times I think lawyers, we kind of wish we were doctors and more in the science end of things. But the fact of the matter is the law is not science. The law is a human profession. It is dealing with people, dealing with concepts. Yes, we have these hard and fast rules that we say we use, which is the law. But the fact is it's a human profession, and that's what we're dealing with all the time.
Have you heard of
humanity?
the elephant and the rider analogy? Where the analogy is, and I think it came from, well, I don't know if it was originated from this book. The guy's name is Jonathan Haidt, and I probably butchered that, but he wrote a book about human behavior. And the analogy is there's a rider, a small rider on top of an elephant, and we all think that we make rational decisions based on logic, and that's the rider. But at the end of the day, our decision making is really our emotions, and that's the elephant.
I like that.
And for you, John?
Well, hold up.
Journalism-
We didn't hear how John got into private practice, right? We stopped at the prosecutor's office.
Well, we'll get in there.
We'll get there? Okay.
We gotta highlight the prosecutor part in both of these great humans.
Okay.
That's what we gotta highlight.
The persecutor part. I get it. Yeah.
You took a class, journalism and law.
So my side of it is kind of storytelling. As a journalist and a journalism major, you learn to kind of tell a story and maybe communicate and sometimes do it very quickly. And because of your story is only going to be a few seconds or a few minutes long. And that's kind of the aptitude I think this adjunct professor saw in me. And that's why he said, maybe you should go to law school. And so it was just, it's one of those things where, life has so many twists and turns, but that's really the fork in the road. I remember that one to this day. I decided to go to the right instead of to the left. And who knows where life would have been had I said, nah, I'm not going to do that.
What's interesting is that one person saw something in you, and that one person changed your trajectory in life.
Mm-hmm. Very much so.
And we often lose sight of that, right? Our day-to-day interactions with other humans and how they mold where we go. So now Sharif wants to focus on the fact that neither one of you still practices as a prosecutor. I'll leave it to you, Sharif. Go ahead.
Well, you spent a number of years in the prosecutor's office, right, John?
The first 10 years of my practice or of being admitted to the bar, probably 9 of them were in a prosecutor's office. There's a little bit of a hiatus where I was enticed to go to be in-house counsel for Nationwide.
Okay.
And so I worked with some guys who all we did was represent people who were insured by Nationwide but were being sued. And it ended up being almost 95% traffic accidents and soft tissue injury and a lot of trial work because, we just didn't settle a whole lot. The adjuster would say, go throw it to the jury. But it wasn't what excited me. It didn't have me waking up every morning going, oh, I'm excited to go to work. Where the first 6 or 7 years of my practice, which as a prosecutor, best job in the entire world. Still to this day, I say it's the best job in the entire world.
I agree.
John, do you share that sentiment?
Yeah, I actually do. I remember that those first 4.5 years in Harrisonburg, Virginia, I am still friends with everybody that we worked with. It was a relatively small office, no more than 6 prosecutors at any given time. But we were young and we worked long hours, probably longer hours than I work now. But we loved it. We spent time socially afterwards. We worked all day. That was the best job I've ever had.
I've listened to some of your other podcasts, and Sharif, I was mad because I can't remember who you were talking to, but you stole my line. And I'm like going, hang on, how did he hear this? This is my line. Because you used the phrase about being a prosecutor and about waking up every day and just doing what's right.
Yeah.
And that is my line. It's the only job I know of in the legal profession where your client is justice. And so you wake up every morning and you just do what you think is right. And if the person's a bad person you're prosecuting, then you go after them with all the gusto in the world. But if the person's a good person who just made a mistake, you have the power to help that person as a prosecutor. And it was unbelievable to be 27, 28, 29 years old and have that kind of power. I loved it.
So why the switch to criminal defense?
That could be a podcast that could go on forever in my life.
Sure.
It's called Politics.
Yep. That's exactly.
And that's a podcast for a different day.
You touched on something, John, is that you waking up and looking in the mirror and you're like, you know what? I'm going to go do the right thing today. I'm going to go do the right thing. That's my job, is to pursue justice. through this particular vehicle of truth. And that's why we harp a lot on being a great human, because if you don't have this foundation, if you're not cut from a particular cloth, you're not going to make the right decisions as a prosecutor. And you won't make the right decisions as a defense attorney as well.
So my phrase is, you do what you think is right. Okay. So I'm not even going to come close to saying I'm a great human. There are probably a lot of defense attorneys when I was a prosecutor who didn't like me, but it's what you think is right.
Exactly.
And if you have that base as a good person, then what you think is right is, at least in my mind, it was always the right thing.
I've always thought the best prosecutors are those who have spent time doing defense work. Niall, to me, is an exception, and I've told him this a number of times, how he can appreciate the other side without having done that work. But I just remember when I was doing my internships in law school with the prosecutor offices, and I just saw the other side as a bad guy, and we had to get him. And then I did a bunch of defense work in the Army, and then I became a prosecutor in Henrico. And I thought I had a much more balanced view of things because of that experience.
No, I think that's absolutely true. And it works both ways.
Sure.
I mean, I think the best defense attorneys were people that used to be prosecutors, just because you know what the other side is doing. You get an insight into what the other side is thinking if you have, in fact, done that job before.
That's right.
So.
And their motivations, why, and their incentives. I remember it was a case in the Army, and it was a stupid case, overcharged. And I remember going hard on the prosecutor, like, what are you doing? Like, this is dumb. You should get rid of this case immediately. And I remember him doubling down. And I think, looking back, that I was a disservice to my client by being as aggressive as I was, because I didn't appreciate that prosecutor had already briefed the commanding officer saying this is a good case, such and such. I basically didn't give the prosecutor an opportunity to go my way and save face.
Right.
And I wouldn't have known that had I not, I didn't know that at the time, but I've since learned that based on having done both.
Yeah. And kind of a corollary to something I think Niall said earlier, I've sometimes thought to myself, if I did ever go back to being a prosecutor, I'd probably be better than I was when I did before, because I've been a defense attorney. I remember when I was a prosecutor, at least when I was a young prosecutor, I used to think everybody was just evil. The world's filled with evil.
Right.
There's people that shoplift, they're terrible, Now, as a defense attorney, I actually sit down and talk to them, and they're not evil. There's not nearly as much evil in the world as I thought there was when I was a prosecutor.
Yeah, I mean, most crimes are crimes of circumstance,
circumstances and stupidity, people doing dumb things.
So when people ask me, how can you defend these people? My line is 95% of the people I represent are good people who have just gone and done something stupid.
Right.
5% of the people I represent are not really nice people. But if 95% of your job is helping nice people, that's a pretty good job.
Mm-hmm.
And to touch on that, John, there's something that I often repeat, that a prosecutor's job is to put both the defendant and the victim in a better position on the way out of the system than the way into the system.
Absolutely.
We can't lose sight of the fact that when you represent the community, you also represent the defendant.
Right.
And if I don't do a good job by putting this defendant in a better position by addressing, is it substance use disorder? Is there a mental illness that we missed? Is it just the circumstances of poverty? If I don't address certain things and I put them back out just by punishing, just strictly punishment, and I don't work on the root, then as a prosecutor, I take hand in the next victimization. Often, as a young prosecutor, you don't appreciate that. You don't appreciate that, hey, this defendant is also part of the community. Human beings, doesn't matter if it's the victim or the prosecution, one thing they have in common, and I've said this before, is they're 99.9% genetically identical.
Yeah.
Mm-hmm.
And it's usually a decision that took 5 minutes, literally 5 minutes.
5 seconds.
Or even 5 seconds that they may be spending the rest of their life for. And one thing that I often hear you say, Russ, is that you got to find the silver lining.
Yeah.
Talk about the silver lining.
Well, that's because the fact of the matter is, when you're doing this from the defense point of view, again, as John said, I agree, 95% of the people are basically good people who did bad things. The hardest cases are when you are dealing with that 5% who it's kind of hard to find the good in them. And I know we've both had people like that before. Not many, not nearly as many as people think. But I mean, I am certain that both John and I have sat knee to knee in a jail holding cell interviewing somebody that we genuinely thought was dangerous. I know there have been a few that I've had that are like that. But still, as a defense attorney, you got to find the positive that you're going to use.
Or the legal issue.
In that case. Or the legal issue. Exactly.
Yeah,
For those 5%.
Niall's smiling at me because I had one of those not long ago.
Yeah. It doesn't happen a lot, but it does happen. And it's eye-opening when it does. But you got to find the silver lining in this case. I can say I'm lucky enough that I feel like I've always been able to find something. I haven't had that case yet where I absolutely couldn't find anything. I've come really close lately.
I agree 110%. And I could talk about 2 or 3 right off the bat cases where I had that situation. But what I'm always amazed about and so grateful to have Russ as a partner is Russ seems to be the go-to guy in Henrico for the troubled clients, the ones that have fired 2 or 3 other lawyers.
He is.
And he always gets it to trial. And he always gives these defendants a fantastic defense. And it's just, I think he uses that psychology background by communicating, connecting to these people, by trying to find that silver lining. And so that's why I'm like going, dude, you are just so much better than I as a human.
That's awesome.
I don't know about that, but
Wow, that's awesome. So if I'm going to be completely transparent, which maybe I shouldn't, when there are those difficult cases, my ego gets involved. I'm like, well, hell, I mean, everyone thinks I'm going to lose, but if I can win, beautiful, right? And I had a few of those in the Army. It was a lot of fun, but there is that competitive spirit about being a trial lawyer. In fact, if you don't have it, I don't think this is a good profession for you. It's very similar to athletics in a lot of respects, right? I mean,
but I think that might be the key about how you take that difficult client and keep them on your side, because you have to say, you know what? Well, okay, you want to go try it? Let's go try it. Come on, here's how we're going to go do it. And you show them that you're excited to get into that courtroom, because you never know. Maybe I'm going to pull that rabbit out of the hat. You just never know.
which does happen.
It has happened.
It has happened.
sure. And at the end of the day, you can sleep, right? I mean, if you won, government didn't do a good enough job. That's not our fault. That's the government's fault.
And that's the way you have to look at it from the defense point of view.
No, absolutely.
It's not about whether your client did it or not. It is, did the government prove it? That's what it's
right. So community is upset. Go pay your prosecutors more. Give them more resources, which is an issue, right? And actually, one of my partners a couple days ago was telling me that there's been reporting lately saying that for the court-appointed list, it's, what is it? I mean, there was 4,000 some court-appointed attorneys a decade ago, and now they've lost damn near 50% of them.
And Russ, you read an article recently.
Yeah, what you're talking about is the Joint Legislative Audit and Review Commission issued a report basically analyzing the criminal justice system. Yeah, they had various conclusions that they need more prosecutors, they need more lawyers that are willing to accept court appointments and represent indigent people. The one fact that I thought was absolutely fascinating in the report was they did an analysis of the results in cases, whether your lawyer was court-appointed, public defender, or retained. They were virtually identical. There is an old trope about public defenders aren't very good at their job. Court-appointed lawyers aren't very good at their job. Statistically, that's just not true. The results were almost identical for all 3 categories.
That's a good argument against jurisdictions that are trying to push for public defenders' offices, right?
Yeah, and I can't tell you how many times I've seen lawyers who were court-appointed, who have great reputations and are fantastic lawyers, get subbed out with lawyers who, retain lawyers who I wouldn't hire, right? Well, and it's kind of wild.
I don't want to monopolize the conversation, but you're touching on something that I personally like to talk about. I personally think if you're going to be a criminal trial lawyer, doing court-appointed cases is a necessity. You need to do it. And the reason is not because it's not the yearbook answer of you must do this because it's a good thing for the community. It's because if you want to be a better trial lawyer, you need to do it. When I was much younger, I'm too old to do it now, but when I was much younger, I used to study judo. When I studied judo and was going to the dojo 3 times a week, if somebody had attacked me, I would have responded in a judo fashion. Now, that's not the case, but what I'm talking about is basically muscle memory, which is your brain. If you are a trial lawyer, it's the same thing. Trial work is a martial art. And being able to respond to objections, make objections, sense what a judge or a jury is thinking, that only happens if you do it a lot.
Yeah.
And when you take court appointments, you're in court every day.
I agree. And you know what? Where that's really an issue is the civil bar. If you are a young lawyer now, I guess with the exception of joining a high volume insurance defense firm, good luck getting into court, right?
Right.
I mean, if you're lucky, you get a jury trial.
Right.
In a year, right? If you're lucky, and that's provided your firm's even going to let you do it.
Yeah.
That's why I do both personal injury and criminal defense to try and get in the court.
Because you're in court.
Yeah. I went to the Jerry Spence College in Wyoming this past summer, and there were a lot of lawyers there who did the same. So it's not uncommon. I've found that there's a lot of and really successful lawyers who have a PI practice, but also a criminal defense practice. And it was actually really cool seeing that because they're just genuine trial lawyers.
I think it's just the more you do it, the better you are at it.
Well, to go back to the court-appointed stuff, the court-appointed list in Virginia is one of the worst-paying states in the country.
Yeah.
Which is, I mean,
think
it's
we're
ridiculous.
50th out of 51 if you count D.C.
And what frustrates me is a few years ago after George Floyd, we had the blue wave, right? And it was criminal justice reform. But anything that would make a difference, which requires the spending of money, it wasn't passed.
You know, Sharif,
Henrico is very lucky. The court-appointed list there is excellent. But at the end of the day, if a person's trying to make a living on a court-appointed list, they can't survive with a couple cases a day. They need 10, 15, right? And
Well, just take a misdemeanor DUI. You get appointed to represent somebody on a DUI. The cap is $120. That's what you're going to get paid. And so to do the DUI correctly, you've got to have your client come in and meet you. And so you take a half an hour to talk to them and figure out who they are and what's going on. And then there's body worn camera. You watch that. That's another half an hour of the stop and what's going on. And then you have to talk to the prosecutor. And then you have to, let's say it's the only case you have. So you have to drive to the courthouse and then drive back to your office. You're spending 2.5 to 3 hours. And you're making $120, so your hourly rate is $40.
That doesn't include the bond motion potentially.
Right. Oh,
it doesn't include the return, if there is a return, if the trial's rescheduled. Who knows? It's ridiculous. And then to think that a felony, right, is what's the cap, 445 or something like that, and that could turn into a jury trial, right? And you're gonna get $445. It's just insane.
That's exactly right.
And I don't understand why the General Assembly hasn't changed it. I'm sure the answer is politics, right?
I'd say it's politics. There's no lobby for criminal defendants.
That's right.
So people,
Jim McLemore told me, it's like, at the end of the day, if there's a choice to send money to elementary schools or money to help criminal defendants, we all know what the answer is.
But the system needs it, and the system you have that many cases and not enough prosecutors and defense attorneys on both sides to handle them. Eventually the system is going to break down, and if you don't get proper representation, you're violating the Constitution. That's going to result in lawsuits.
Sure.
That's going to cost the state money.
Well, it's the same issue, right? I mean, we don't pay police officers enough. We don't pay teachers enough. And yet we ask them to do the most important job in our society. It's incredible to me.
Right.
it's a self-disciplined profession. When you talk about the statistic, right? If you're either court-appointed or you're trained or it's a public defender's office, when you get up before the court and you're putting your case on, it doesn't matter what you're making, right? You want to do the best job in front of your colleagues, in front of the bench, regardless whether it's $120 or not. If John gets appointed on a misdemeanor DUI, he's still going to put the same amount of work as he would if he was retained.
Well, but that explains why
because he's got a reputation.
List
exactly.
has dwindled, right?
Yes.
I mean,
but I always looked at being on the court-appointed list as a loss leader. If you remember your econ class, there's some things that you're going to lose money on, but it's going to lead to better things. So it's because I give my all to the $120 client that my reputation in the community, when that person's friend gets arrested, you know who you need to call? You need to call Rockecharlie. I mean, I'm always amazed that my job is to get people out of jail, but my reputation in the jail, at least from what people tell me, is like every defendant says, no, you need to get Rockecharlie. Why are you saying that? If you're my client, you're in jail, yet you're speaking kindly of me. I don't understand that. And it's because they see the effort.
Yeah.
I can't control what the judge says, but they damn sure see me trying.
Well, the fact that you're fighting for them and that they see that you care,
right?
That's what they want.
Right.
And it's also, sadly, a lot of the defendants haven't had that before.
Very much so.
And so it's a privilege and it's an honor to see someone like yourself fighting for them.
Thank you.
I'd be duking it out with a defense attorney, and we'll walk out together shaking hands, and then I see someone that was sitting in a gallery run up to the defense attorney, say, hey, can I get your card? Can I please get your card? Yeah. And it's because they saw, it's a court-appointed case, but they saw this attorney fighting for his client. That's powerful. So we talked a lot about just the day-to-day practice, and we kind of didn't touch on the years of experience. We have, John, you do both federal and state.
I do.
Russ, you mainly do
mainly state. I used to do some federal stuff, but I don't anymore.
You do mainly state. We're talking about over 400 juries between you two, if not way more. Okay,
way more.
Probably more.
But way more, right? Let's talk about the jury trial. And it's the trial, and it's important because that's why we do this. We just love to put the trial on, right? We probably hate the prep and love the trial, and that's a common theme for everyone. Let's talk about the jury trial. When you're thinking of a trial for your client, how do you prep for it? What is the most...
The way I do, and I'm not saying everybody should do it this way. I think you have to find your own way to do it, because insincerity is the worst thing that will hurt you in front of a jury. So you got to be yourself. Well, first you got to learn about your case. Assuming you've done your discovery, you've learned, you know the facts. I start preparing for a jury trial by preparing my closing argument. This is what I want to say at the end of the trial. And then I go back and look at opening and direct examinations and cross examinations. And I try to make sure that I get everything in that I want to be able to say in my closing argument. So that's where I start. And maybe that's just because closing is my favorite part of the trial.
Okay.
But I start with the closing argument. I want to be able to say 1, 2, 3 to the jury, and then everything else is preparing to make sure I have a basis for saying those things.
How about you, John?
I try to find the one thread that I'm going to pick on over and over and over again. And it's usually just one thread because my mind is not strong enough or I'm not intelligent enough to juggle too many balls. But I find that one thing. And if there are other things that aren't important to me, I'm willing to stipulate. I'm willing to do anything. Let's focus in on this one thing. And I think if we focus in on it and we really look at it, ladies and gentlemen, you're going to see that I'm right and they're wrong. And I start from the very beginning. Let's look at this one thing. Sometimes it's 2 things. Sometimes it's 3. The thread might be they got the wrong guy, or it might be something completely different. I'm usually focused in. And it might come from my days of being a prosecutor back pre-1995, when there were times when we were doing 2. I've done 3 juries in one day. And it was because you had to get to the heart of the matter, because the judge who had a jury waiting in the hall to come in was going, move along, move along, move along. I loved Judge Williams in federal court, a nice, nice man. And his favorite thing to say was, Mr. Defense Attorney, these people are awake and they're intelligent. They've heard that all before. Move on. And it kind of diminished you when he did it. So you didn't want Judge Williams to do that. So boom, moving along is kind of my mantra.
How in the world do you 2 or 3 juries a day? That doesn't exist now.
Oh,
right?
no.
And what?
Right.
And
Oh,
you know,
no.
Learned Berry talked about this. I guess there's just so much more that goes into a trial nowadays than
Well, y'all love voir dire,
not
especially
in
with,
Henrico.
yeah, with the old school judges. Judge Harris is old school, the old school judges. And I was actually part of the case that did this and that made the law in the Supreme Court. Over in South Richmond, the chief deputy Commonwealth attorney's wife was in the jury pool. And it was a criminal case. And the defense attorney goes, I moved to strike because of her relationship with the Commonwealth attorney. And the judge went, Mrs. So-and-so, will you stand indifferent to the cause? Yes. Do you have a prejudice against anybody? No. Will you listen to both sides and be fair? Yes. Well, I don't care who she's married to. She's not struck. And the Supreme Court said that, yes, that's fine. And so the judges followed that. And then when you started talking about, do you like the color blue or do you like the color, boom, they would cut your knees off. And so your voir dire in those days was, can you be indifferent to the cause? Will you give both the Commonwealth and the defendant a fair trial? Yep, then thank you very much. And you sat down. If the defendant didn't testify, the jury never had any idea how many times that person had been convicted of a crime because you couldn't mention it. And so that's why I have done probably in the 9 years I was a prosecutor, I bet I did 300 jury trials in those 9 years. And it was because if it was a little piece of a rock of cocaine and the defendant had a record a mile long, the defendant would never testify. Right. And so, okay, they found this, and ladies and gentlemen, what do you want to do for a $25 rock of cocaine? They're asking you to put him in the penitentiary, please. And they go off, they find him guilty, they come back, they give him a $100 fine.
Okay, so they were sentencing.
Yeah. Oh, yeah. The jurors were sentencing all in one
proceeding.
Yeah. Got it.
So the way we did 3 is we did a voir dire for the first trial. The judge told him come back at 1. Then he brought in 20 more people, put them in the box. We got it down to 12. He put them in the jury room. We brought in another 20 people, got it down to 12, did that jury. When then they were going to go out to deliberate, they switched with the other 12 people. They came into the box. They heard their evidence, maybe had to go take a break because the verdict was already back from the first trial. And then at 1 o'clock, the last 12 people came in and we did it then.
That's wild.
So we did 3 juries and I bet I was home by 4.
Well, you already talked about a little bit about what's different, but there has to be more than just the not hearing the criminal history.
Well, there's less forensic evidence, right? And that's the thing. Now you bring in experts and it's qualifying your expert. Every case we have as a prosecutor between 3 to 5 experts. And that's what takes time.
Yeah.
Your lay witnesses do not take much time.
Right. There's actually, at least in the PI world, there are a lot of the big time trial lawyers now are using phrases like speed trial. They're encouraging, like, don't waste the jury's time. You don't need an hour-long direct if it can do it in 10 minutes. Right? So just move. And actually, the trial that Ben and I had, we had 12 or 13 witnesses. We finished in a day.
See, I know you've talked to Lerner Berry. Lerner Berry is the key of an hour-long direct examination. No way. It's a conversation that you have with your witness that you're bringing out the most important points. A great direct examination is right on the line of leading. You bring them right up to the point where you're probably just about to get an objection when you stop talking and you let the witness talk. And you let the witness go until then you interject and lead them to the next point and then lead them to the next point. I never get upset when someone objects to me because I'm leading. Well, it means I'm doing what I need to do, and I'll scale it back until they object next time. And so that's how you do. And I learned direct from Lerner Berry.
I think that also dovetails into what John was saying earlier about finding the one thread or, your 1, 2, maybe 3 arguments. A lot of time, and I think younger lawyers do this, is you don't want to get caught up in the weeds of fighting about everything you can possibly think of.
The shotgun approach.
Find your one point that's going to make a difference in front of the jury. Focus on that. If there are other little issues that, maybe you're even right about it, but it's not worth bringing up because it's not going to sway the jury one way or the other. And maybe only experience teaches you that. But you got to, in my opinion, focus on the one issue that's actually going to make a difference. Don't get caught up in a lot of nonsense.
A perfect example of that is you have a person who's charged with possession of a firearm by a convicted felon. Okay? The Commonwealth has to prove that the gun actually works. You will find so many defense attorneys who want to challenge, they have to bring in an expert and challenge whether or not it's actually a firearm. When the issue is, did the guy have it or not? And why get bogged down and challenge the credentials of the guy from the Bureau of Forensic Science or whether or not it expels a projectile? Who cares? Okay, it's a gun. But they can't prove my guy had it.
Right. Well, not just that. As an advocate, you're going to lose a little bit of credibility if you're challenging something that's nonsense.
I absolutely think that.
John, it's about keeping it simple.
Yeah.
And focus. The juries.
Keep it simple, stupid.
Keep it simple and stupid. I recently had a murder case where the defense attorney stipulated, I sent the stipulations a few days before trial, and he stipulated to the majority of the foundational questions that I needed. I went from 22 witnesses to 8.
Mm-hmm. Exactly.
It was set for 3 days. Commonwealth finished in a day. And you get to a point, you're like, you know what? I knew where he was going. It was defense of others for him. I knew where I was going. And that's what he honed on, that one issue. And that comes with experience.
Right.
No doubt about
Just
it.
knowing,
knowing
what your case
we
is
say
worth.
that it comes with experience, but was there a defining moment that said, all right, I need to change the way I go about things and adopt this, keep it simple approach? Or
I can't point to a specific thing.
Yeah.
When I go look at my beginning and what I do know, I'll say this. I know the first 4 juries I tried as a prosecutor were all not guilties. I was so down. I was thinking to myself, I have chosen the wrong career. But now looking back, that was the best thing that possibly could have happened. I mean, if I was getting convictions in all of those, I would not have made myself a better lawyer. But that's just one of the things you sort of learn. You realize I've got to focus on certain things. I can't say there's a specific point when I realized that, but over time, you definitely realize you got to focus on the issue that's going to make a difference.
No, that makes sense. Well, what keeps you guys going? Because, I mean, criminal defense, I mean, it's not an easy job. Now, granted, it's a lot more fun than sitting behind a desk doing mergers and acquisitions.
Yeah, that's That's
Thank God for people who like to do tax law. But
you kind of touched upon this earlier. I think maybe John started to answer it. The reason I stopped being a prosecutor was maybe even similar to John. You work for somebody that has to run for office every 4 years, and the politics of doing that wears on you after a while. And you sort of realize you're not going to advance in this job unless you get involved in politics too. And that's not me. I didn't want to do that. So that's why I made the switch. As far as being a defense attorney, how do you keep going? You have to find that silver lining in each client to make you want to keep going. And it is true that sometimes it's get hard because it is a stressful job and sometimes clients can be difficult. But if you try, you can always find that one thing that you like in that person and you're going to try to make out of the case for them.
I'm a people person. I like talking a lot, as you can probably tell, and I like talking to people. So the interaction at the courthouse with my fellow members of the bar, I love that. Interacting with the judges and the police officers and the clerks, I love that. I love interacting with my clients. And the hardest part of the job for me is not necessarily the stress, because I don't know, there's some inner wiring with me that I'm able to kind of move on from the last defeat and move on to the next opportunity fairly quickly. I get over the stress, but it's the disappointment that sometimes my clients, I'm trying to phrase this the right way. So I go out there, I put my own reputation, and I say to the judge, this young man has overcome everything. He's working hard at the program. He's doing what he needs to do. Give him this opportunity. And then a month later, I see he's back on the docket and he's let me down. He's failed me. And so that happening time and time again starts to wear on me. But that happened earlier this week. And I get out of my car, I'm walking into my house, and the FedEx truck backs up. And I stop and look around because the driver rolls down the window and goes, "There's my lawyer. How's it going, dude? I can't tell you how much I appreciate everything you did for me." I have no idea who he is. I don't know whether I did a tremendous thing for him or it was just another really easy case. But he was grateful to me. And all of a sudden, the guy who let me down, I forgot who he is. I like to think about the FedEx dude.
You know, great work leads to appreciation. And that FedEx driver is appreciative of the work that you provided. Human beings respond to incentives, and we find our value, and your value, both of y'all's values, is changing the lives of your clients. That's one thing that kind of fuels that passion to keep doing it and doing it and doing it. We talked about the jury trial, and I know Russ said closing argument is his favorite part of the trial. For me, it's the opening statement. What is it for you, John?
For me, it's cross. It's both the direct examination, but the cross-examination. I think there's an art to cross-examination, and the people who I try to model myself after was a guy who prosecuted in Chesterfield named Mark Kruger. Kruger was the best cross-examinator. Is that a word?
it's a word now.
It is a word now. He did it from a cynical standpoint. He never believed anybody, and he was always trying to get to that one point. But man, you had to be careful client on the stand against Mark Kruger because he was going to find a way to mess him up. And then the second person is Judge Claire Cardwell. Claire Cardwell, she always had a theme and where she wanted to go, and she was systematically could devastate a witness. And I just have always wanted to do that because I think if you ask your questions in a certain way, that theme, that thread that you're pulling on, you can bring it out even against an adverse witness. The instructions say the question is not evidence. The answer is, the jury's listening to that question.
That's actually powerful because Sharif and I talk about a great cross is actually a mini closing argument.
Yes, it is.
Because you're the one that's talking. And it doesn't matter whether or not, Sharif, you have a witness there, right? It doesn't matter. And we've touched on that.
Well, it's the Terrence McCarthy.
Hey, you're right. It is the Terrence McCarthy approach.
If our listeners want a good book on cross-examination, there's a book by Terrence McCarthy, and it's just fantastic.
And if you do a great cross, doesn't matter if you have a body in that witness chair or you don't.
Right.
If we can tell war stories.
Yes,
Absolutely.
of course.
Let me tell a war story about, and it's Claire Cardwell. I'm prosecuting, she's defending, and it's a rape case that occurred on a couch. And Claire starts asking the victim what she was wearing. And she was wearing jeans. And then the position of the bodies between the two. And all of a sudden, Claire just goes, and how did those jeans get to your ankle? And she lifted up her hips. And then she just a little hip movement. And the victim kind of looked at her, and the jury all of a sudden realized she had to lift up her hips to let the pants come down. Consent, done. Jury was back in 5 minutes, not guilty.
That's amazing.
And it was all that one little thing. You had to lift your hips up to let the pants come down.
So
amazing.
How did you cross that, right? So you saw that.
Then.
And you just pounced on it.
No, I didn't see it. No, I'm prosecuting.
Oh, you're the prosecutor.
I'm the prosecutor.
Okay.
She was defending.
And then she pounced on it.
And I'm like, okay, boom.
Just thinking about that, it is a dangerous question, though, right? I mean, because let's say the answer is, well, it's because your client did this to me.
Or he pulled them or whatever.
Yeah.
Come off, right.
But she
felt it and she
up.
went with it.
She set it up in such a way and had him on top of her and the weight and all that. And then, okay, so how'd those pants come past your hips?
Wow.
And it was kaboom, done. Drop the mic.
Justice was served. Talking about stories. I'm going to start with you, Russ, and then I'm going to go to John. So 20 years from now, you decided to retire and you're sitting there having a cold beverage, thinking back about your career.
Here's the way I will answer that. Every lawyer, if you do this for a while, you're going to have a series of cases
Yes.
that you're going to always remember that are just, they will stick with you for various reasons. I remember the very first one I had, and the reason I've remembered it recently is because of another one that I had more recently, and they're both cases that people may have heard of. So I'm going to be careful about how I talk about them. But the more recent case was in Henrico County. It was the murder of Lucia Bremer.
Yes.
And the young man who was accused with that and has now been sentenced for it was a young man by the name of Dylan Williams.
Yes.
He was 14 at the time the offense happened, and he got 60 years. That was a hard case because of what happened, because of getting to know Dylan. It was just a difficult case all the way around, and it's tragic for everybody involved, and I don't want anybody to get the impression that I don't feel that way because it was awful for everybody. But again, a 14-year-old young man, for something he did when he was 14, got 60 years. Now, go back to 1993. I was a prosecutor in Harrisonburg, Virginia, been out like 3.5 years. I happened to be the duty attorney who was on duty in September when I got called out by the sheriff's department to go to the scene of a crime where a woman had been stabbed to death by her 12-year-old and 13-year-old daughter and the 14-year-old boyfriend of the 13-year-old. It was an awful case, and it was the first awful case I ever had. Seeing the scene I still remember the scene of that crime because when I got there, the body was still there. They were still taking pictures. And again, it was crime that was committed by a 12-year-old girl, a 13-year-old girl, and a 14-year-old boy. What they did was the 14-year-old boy hit mom over the head with a miniature baseball bat, and then the boy and the younger girl held her down on the bed while the 13-year-old girl stabbed her repeatedly with a butcher knife in the back of the neck. It was an awful, brutal crime. The law at that time said if you're under the age of 15, the worst that can happen to you is that you will be held in the Department of what was then called Youth and Family Services until you're 21. And that's what happened. We had multiple trials. They appealed their juvenile cases, so we had to try them in front of a jury in circuit court. They were all convicted. They all got the maximum penalty available at that time. A lot of people were up in arms about the fact that they should have gotten more. They should have gotten more, but they didn't. They were held till they were 21. Because that case was something that just stuck with me, I've kind of, from a distance, followed what happened to those kids ever since. The 14-year-old boy kind of lived a life of what you would call petty crime, maybe possession, shoplifting, things like that. Ultimately, he passed away in his 30s. I don't know the reason for what his death was, but the two girls never really did anything again, maybe a traffic offense here or there. And so I think how we have drastically changed as a result of those cases as a society. Those kids who everyone was up in arms that they were only going to be held till the age of 21 never did anything like that again. Never did they do anything like the horrible crime they committed when they were young. And yet, 30 years later, Dylan Williams does an equally horrible, horrible thing, and we can throw that life away. That troubles me. I don't know what the answer is.
We often think jail fixes things, prison fixes things. One of the reasons why I knew I wasn't going to be a career prosecutor and I decided to switch was because I struggled with, all right, well, sure, they did it. 3 years, 6 years, 9 years, what's the difference? And I still struggle with that. We actually talked about this at the beginning of this podcast. But at the end of the day, we want the defendant to be in a better position to be a contributing member of society and to have learned from this, right? And sometimes our efforts in sentencing take away from that.
Why didn't the court see the silver lining, assuming you saw a silver lining in Dylan Williams?
I don't know the answer to that. You might have to get the judge in here.
Well, I'm not going to mention who the judge is.
We'll
but
subpoena the judge.
We're
We'll
hoping that
subpoena
he'll
the
be on
judge,
the podcast
Right.
sooner than later.
I feel like as a society, we've kind of changed and we have gotten more harsh. Maybe we should. Maybe we should be. I don't know. I'm not going to speak on behalf of society, but I feel like we now, more so than we used to, think that the only solution to somebody who does a bad thing is jail. It's kind of like when I sometimes think about, do we really have a presumption of innocence? We talk about it, and it's definitely in the law. But if you ever look at a news website and see a news report that somebody has been arrested for a crime, somebody has been accused of a crime, and then look at the comments, you will see that people who don't trust the media and they don't trust the government, when they see in the media that the government has accused somebody of something, they're ready to type an angry comment that, I hope they bury that person under the jail, when all it says is that person was accused.
Yeah, well, the court of public opinion's now ruled, right? Good luck coming back from that.
Right.
Well, it's simple. If you see a car on the side of the road with a police car behind it and lights are on, the first thing that comes to mind is, what did he do?
Mm-hmm.
Yeah.
What did he do?
Well,
But
this,
you know what? He has a flat tire. That's
So-
what it is. He's got a flat tire. And that's where the presumption of innocence is no longer there. And,
Right.
and I'm a prosecutor,
Yeah,
right?
right.
But and we're like, hey, what do you think he did? Speeding? Is it DUI? Is he outside of the car because they're doing field sobriety tests? Or is he opening up walking to the trunk to get his spare?
Mm-hmm.
But that's what comes to mind first.
Well, I found an angle. This is why voir dire is so important, right? I mean, presumption of innocence.
Yes. And that's a question you ask actually in voir dire, if you're allowed to ask him voir dire.
Well, I don't think the question is, well, you all
use
believe
the
that
same
he's
hypo.
innocent, right? You say, listen, that my client is sitting next to me. I understand, and I was there at one point where he's here. He must be here for a good reason. What do you all think about that, right? I mean, that gets to the...
Yeah.
They're all going to give you... Yeah.
I did a trial recently in Chesterfield with another very good attorney named Doug Ramser, and he handled the voir dire portion, and we talked about that. And the way he addressed it with that particular jury was he not only asked the jurors about whether they believed in a presumption of innocence, he actually then had them start giving examples of it. And the judge in that case was letting him do it. He said, can everybody think of a reason why this might have happened? And a perfectly innocent explanation for it. He actually
Planting the seed?
let them do that. And the judge let him do it. Now, I had another jury shortly after that on my own in a different county. And I tried to do the same thing, and the judge in that trial said, "No, we're not doing that, Mr. Stone." So it kind of depends on the judge you have.
It does, and I'm on a crusade to change things in Virginia. But the law is broad. We have the right to ask these questions. It actually says counsel has the right, or language to that effect. Just Virginia's jurisprudence, for some reason, has just been so tight on voir dire. And I mentioned this in the last episode. I'm not suggesting that we become California or Florida and have a week-long worth of voir dire, but I don't think counsel should be limited to less than an hour, right? And it's weird to actually hear that from the criminal defense perspective, because you think if anyone would get leeway, it would be the criminal defense attorney. And so who knows? We'll see how things develop.
Well, John, now you have that cold beverage in your hand, and you're thinking back. What is one case that just stands out in your mind?
Wow, there's not going to be just one case. I mean, I've gone the gamut from both being a prosecutor and a defense attorney, and sometimes I don't know if it's the case that was the horrific fact pattern, or a case where some humor somehow came out of it. Because that was the other thing that I love about this job, is that it's amazing the situations people will put themselves in, and if you're not in it and looking from it from the outside, perhaps in a very mean-spirited way, perhaps it can kind of be funny. But I guess that's why there's America's Funniest Videos. You ever watch that show? All it is people falling down and hurting themselves. But in any event, ironically, the case I think about the most as a prosecutor is the case Russell Bowles talked about as a defense attorney. I was the prosecutor in that case with the little old lady who was so stately and that got raped by the guy. And Russell was talking about how that was probably his first life sentence. I prosecuted that case. He got life. I had absolutely no problem with that. That was a horrific fact pattern. And I didn't lose a wink of sleep thinking about that guy.
Summary of the facts for those that haven't listened to the prior episode.
A lady who lived in South Richmond had to be, I don't know, age is always hard, but I would say she was in her late 70s. And she was just the epitome of a stately grandmother. She carried herself with class and with dignity, and was just an absolute, if you close your eyes and picture grandma, that's what this lady was. And a guy broke into her house and was stealing some stuff and had her sitting there in a chair. And then as a last second thought, he goes, "You know what? I want to have sex with you." And he ended up raping her. And she came in and testified and just held her dignity with an amazing grace. And the jury was out maybe 15 minutes. It was all one. It was pre-1995. They came back, found him guilty of everything, and gave him multiple life sentences. And I didn't have any problem with that. From a defense side, it's the kind of things that just, I don't know, perhaps it's the case out of Petersburg where my client was accused of burning down a house that had 4 generations of a family in it. And he was not a very nice person. He was clearly in that 5%. And the thing I remember about that the most is he was charged with capital murder. And through strong motions practice and really some good negotiations, we got death off the table, but we're still going to go to trial. And trial's going to start in September on a Monday, but we have pretrial hearings and stuff on Friday afternoon. Now, let me back up in that I've been going down to Riverside Jail to try to see this guy since April, and he had been refusing our visits. And the way Riverside's set up is you walk into this main area, and because he was a super special client, the guards at the front desk would call down to the basement where he was being held and say, "Hey, his lawyer's here." And then the guard would turn to me and go, "He's refusing the visit." So the first 2 or 3 times that happened, I just turned around and walked out and said, "Okay, I didn't really want to see the guy anyway." Well, then one night when I tell my wife that story, she goes, "How do you know the guards are telling you the truth?" Because this guy was so hated that it was possible that the guards could have been just messing with him to keep him away from his lawyer. And I went, no. Wow, that's a good point. Okay, well, so the next time I went, I turned to the guard at the front desk when he said he's refusing the visit. And I went, "You know what? He's got to tell me that to my face." So they took me down there and they opened the cell, and the defendant would yell, "Get the, F away from me." And I'd turn around and walk out. And I did that every time I would try to go see him from probably May until that Friday in September. And so we're now in court. The judge asks him to stand up and said, "Are you ready to go to trial on Friday?" On Monday. And the defendant says, "Nope." And the judge goes, "Why not?" He goes, "Because I haven't seen my lawyer in 6 months." And I'm like, "You gotta be kidding me." And the judge looks at me going, "This guy's charged with capital murder and you haven't seen your client in 6 months?" And I went, "Hang on. I got a little Paul Harvey moment. There's the rest of the story." And I tell the judge that, and I tell the judge I can bring in 5 witnesses from Riverside along with my co-counsel who would try to go with us. And the judge goes, no, I believe you. "Mr. Defendant, is that true?" "Well, yeah, that's true. Yeah, we're going to trial on Monday." But that SOB was going to try to stab me in the back. And luckily, I listened to my wife. So that one I remember.
So, guys, we have a lot of young lawyers and then also law students who listen to this podcast. Some of them have no clue what they're going to do, where they should start. What advice, if you had to offer yourself when you were starting out, what advice would you give now?
If what you want to do in the law is be a trial lawyer, be a prosecutor, be a public defender, or at the very least, accept court appointments if you're going to join a private firm, because that's how you're going to get the experience. There's no better teacher than experience. So actually doing it is the way to learn. If you're not at the point where you can actually do that yet, say you're in law school, go sit in court and watch some trials. If you're not doing it yourself, maybe the best way to do it, but sitting and watching other people do it is probably the second best way to see what a trial lawyer does. You'll see what arguments work, what arguments don't work, how judges react to things, how the interplay between attorneys. I'm a big fan of telling people to just go watch court. I have even had clients who had upcoming juries. I've suggested to them, you know what? Go watch this trial, because if you're going to take the stand and testify, you need to see how a trial works. You need to see what that jury is focusing on. And I've said, just go sit and watch that trial. I don't know if it helps or not, but I think it does.
Since post George Floyd, all these law students have come in and they say, we want to change the system. So they want to go be public defenders. You want to change the system? Be a prosecutor and prosecute the way Niall does, by trying to make the community better, by making the defendant a better person in the community, by giving him that opportunity. The prosecutor has the most power of anybody in the courtroom. You think it's the judge? No. The judge decides whether it's a ball or a strike. The prosecutor decides whether it's a fastball or curveball, or whether to even throw the pitch. And so you want to change the system. You want to educate the police. Do it from the side of being a prosecutor. They can change the system. And then if you're in law school and you're trying to figure out what you want to do, if you like people and you want to help people, then get into the criminal justice system.
Well said. I got another question
baseball
for you.
analogy was brilliant.
It was. Well done. Why be a trial lawyer?
You have to have the personality that makes you want to do it. And I didn't always think I did. I tend to be more shy and not as talkative as, at least when I was younger. So I wasn't 100% sure I wanted to be a trial lawyer. But once I started doing it, I did. I think I was attracted to the intellectual aspect of it, the having to sit and convince people that what you're saying is the way they should feel. That probably goes back to psychology, probably goes back to a lot of things that I don't even know about. But if you like that sort of thing, then being a trial lawyer is absolutely what you should do. If you don't, there's tax law, there's wills, you can do all kinds of things in the law.
John, how about you?
Russ and I are so different yet so alike, because he goes into it because of the intellectual. No, not me. I just like walking in a room and having everybody focus on me.
What's your theme song? Is there a theme song that plays in your mind?
Rocky, of course, man. Come on.
Rocky for Rockecharlie.
There you go.
The more I think on it, I think people are just certainly wired for this, right? I mean, I can't do transactional work. I'd lose my mind. I don't care how much you pay me. I'll jump out the window. And I'm sure there are people who do transactional work who would feel similarly about walking into a courtroom, right? Mm-hmm. And it took me a while to really appreciate that about myself. I wish I could give our younger listeners, young lawyers and law students kind of a hack to figure that out about themselves. But a lot of it's just trial and error, right?
One piece of advice I would give people is you really have to be yourself, because I think I mentioned it earlier. insincerity is sensed by juries. It's sensed by judges. If you're trying to be something you're not, it's not going to work. I know that because when I was a very young prosecutor, we'd go to the annual meetings, the Commonwealth Attorney's annual meetings, and I would occasionally see talks by some of the older prosecutors, and some of them were really fiery in their rhetoric, like TV preachers just, and I was like, oh, that's why I got to be like that. I got to be like that. I'm not like that. But I tried a few times early on to approach a jury that way, to be the, stamping my feet and yelling and screaming. It just didn't work. I never convicted anybody when I did that, when I was a prosecutor. When I started convicting people, winning, in other words, I sat back and I just was myself. I stand up, I talk to the jury, I don't get angry, I don't yell, I don't scream, I don't fight with the prosecutor. I like the prosecutors. If not, I don't think we've had a jury yet, but no. I would love to have one with Niall, but I know he works with people who've had juries with me, and I guarantee you they say, he's a nice guy. I am sure of that.
You touched on something, Russ. You talk about being insincere, and you're right. People see through that right away. I often say those that best connect to other humans are those that wake up in the morning and they see a person that everyone else also sees. It's that same person. And those are the people that are able to connect and actually persuade. If you try to be something that you're not, they're going to see right through it.
Right.
It's like you go to law school, you learn how to be a lawyer, and I'm using quotations, and then you spend the first few years being a young lawyer learning that if you want to be successful, you got to be yourself and actually go back to that person you were before you started opening all those big books, right?
Mm-hmm. Right? Let who you are as a human define your profession, not the profession define you.
Very good.
Yeah.
Rockecharlie Stone. It has been a pleasure, and when we said we are here to preserve the voices of the greats and great trial attorneys, both of y'all stand for exactly that sentiment. So we want to thank you for taking the time today to sit down with us.
Well, thank you. Thoroughly enjoyed it.
I was honored to be asked. Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.